A stack of standard insurance forms sits on an HR director's desk. In months, these routine documents will trigger a massive federal investigation. The company in question is a mid-sized manufacturer. For over a decade, their operations ran smoothly, and their factory floor maintained a genuinely excellent safety record. They experienced no major accidents and no severe injuries. When an employee did get a minor scrape or sprain, the human resources team followed a strict internal protocol. They immediately filed a workers' compensation claim to get the employee appropriate medical care. They assumed that once the insurance paperwork was submitted, the incident was fully resolved. That specific assumption brought the United States Department of Labor knocking on their door, carrying a penalty exceeding $400,000. The factory's physical safety protocols actually kept workers out of harm's way. But by misunderstanding the paperwork, the administration had armed a legal time bomb. Workplace injuries in the United States fall under two entirely separate jurisdictions. First, there is workers' compensation. This is a state-level insurance system. Its strict purpose is to manage financial payouts and ensure injured employees receive their medical care. The administrative process splits. The right side is OSHA Recordkeeping, a federal regulatory system tracking safety data for legal accountability. But this HR department operated entirely on the left state insurance side, leaving the federal side completely blank. Federal law requires businesses to maintain a document called the OSHA Form 300 log. Think of it as a running ledger for your workplace. Every work-related injury that requires medical treatment beyond basic first aid must be recorded here. The company successfully protected their employees' finances through the state. But by failing to notify the federal government, they accidentally created a discrepancy. They were maintaining a shadow ledger. Consider a routine incident. A warehouse worker sprains their shoulder lifting a box. The injury is minor, but a doctor writes a prescription for a muscle relaxer to help with the pain. The HR team immediately files the worker's compensation report. The insurance covers the clinic visit. The worker gets their medication, and the internal file is marked complete. Because that treatment involved prescription medication, it crossed a specific regulatory threshold, known as 29 CFR 1904. The federal government officially considers this a recordable injury. Look at the timeline here. OSHA legally mandates that an employer must log this incident on their Form 300 within exactly 7 calendar days of learning about it. On day 8, the worker is healing and the insurance claim is fully processed. However, the OSHA log sits in a filing cabinet, completely blank. Because that deadline passed, the company is out of compliance. A simple administrative delay has officially become a prosecutable federal offense. This exact oversight repeated itself 11 separate times over an 18-month period. Every year, companies of this size are required to electronically submit their summarized safety data through OSHA's injury tracking application. Because of their blank 300 log, the manufacturer submitted a mathematically perfect record of 0 injuries. This pristine data fed directly into OSHA's site-specific targeting algorithm, a system designed to flag statistically improbable safety records for unprogrammed inspections. A federal inspector arrived unannounced. One of their first procedural steps was requesting the company's workers' compensation loss runs from their insurance provider to compare against the OSHA 300 log. As this diagram illustrates, the inspector found the proof immediately. 11 documented medical injuries on the insurance ledger corresponded to exactly 0 entries on the federal record. Those insurance files proved the company's management had clear knowledge that the injuries occurred. By possessing that knowledge and failing to record it, the citations were elevated to willful status, carrying maximum penalties of over $160,000 per violation. The initial shock of the inspection culminated in a penalty exceeding $400,000, a staggering amount of capital drained directly from the company's bottom line. Look at the cascading impact on this chart. The federal fine is only the baseline. The company then had to pay thousands in legal defense fees, absorb massive spikes in their workers' compensation premiums, and fund a mandatory overhaul of their compliance department. The human resources director never acted out of malice. They were operating inside a siloed corporate process, managing the immediate needs of the workers without seeing the broader regulatory picture. Take a close look at your own organization. How insulated is your reporting system from a simple disconnect between state insurance processing and federal safety law? Avoid these regulatory blind spots. Subscribe to HSEstudy for the insights you need to keep your organization safe and compliant.